Hello, folks. This is Kip from Malek Malek, and today I'm going to be talking about a case called Bowie versus Greater Cleveland Regional Transit Authority. It's an Ohio Supreme Court case from May 5th, 1996. Um, and this case is important because this is a way that helps us get you folks comp in certain situations. And what it's called is a Bowie review, and the Bowie reviews comes from this case. And essentially, what happened in this case is this individual was working. I guess he was maybe like a transit train driver up in Cleveland, and he struck a backhoe going 5 miles per hour. Comp was requested, temporary total disability comp was requested in a C86 motion. So if you don't know what a C86 motion is, it's a way that you request things through the workers' comp system. So if you want treatment, if you want comp, frankly, if you want anything, that's how you communicate with the BWC to get that thing. It's C86 motion. I think I've talked about in other videos. Nevertheless, this individual had requested comp over a closed period of time from January 18th, 1990 to May 31st, 1990. And again, the date of injury on this one was January 17th, 1990. So it went through the industrial commission process, I think one or two hearings, and then the industrial commission refused to order comp be paid based on a review report performed by Dr. Katz. And Dr. Katz had examined the injured worker on July 12th, 1990. So if you're following along, that's 7 months after the date of injury, roughly. So date of injury, January 17th, 1990. This guy sees the injured worker months later. Apparently, he didn't examine any of the prior medical, the ER records or whatever. He just examined the injured worker on that date, and his conclusion was the injured worker was able to go back to work. And so the IC denied comp based on that, and then this went through there was a mandamus on this, and it went to eventually made up the Supreme Court. And the Supreme Court essentially said that's not some evidence upon which the Industrial Commission could rely upon in order to deny comp. Doesn't mean this guy gets comp, but it's basically saying they can't rely on that report. And they basically booted it back to the Industrial Commission because the Industrial Commission determines whether or not you get comp. And so what the rule that we get from this case is that, and this is what we end up doing with your medical providers, is what needs to happen if you are being examined by, like, let's say you go to a physician of record. Let's say this example, you got injured January 17th of 2023, and for whatever reason you don't end up getting to some doctor who will certify you temporarily and totally disabled until, let's say, July 12th of 2023. And so in this example, again, you're off work from January 18th, 2023 to 5/31 of 2023, and you're requesting comp. So maybe you've gone back to work after that point, and then you're eventually examined. What would need to happen is your examining doctor, and this is what the Supreme Court says in this case, is the examining doctor has to have reviewed all the prior medical before the point of the examination. So from January 17th, 2023 up till the date of the examination, July 12th of 2023. So that reviewing doctor who's certifying you, they hadn't seen you, that doctor hadn't seen you prior to that point. So the only way they could credibly certify you temporarily and totally disabled is they have to have reviewed all the prior medical. And if they reviewed the medical and they've examined you, and based upon their examination of you and the review of medical, then they could opine, I do, in my medical opinion, to a reasonable degree of medical certainty from, for example, July 18th, 2023 to May 31st of 2023, I do believe this individual was temporarily and totally disabled for whatever conditions they're certifying you for. So that's what this Bowie case stands for. It's pretty simple, but you can get back periods of comp, or you get periods of comp before your certifying doctor has seen you, assuming your certifying doctor has reviewed your prior medical records. And this comes up more regularly than you would think, simply because some people they'll go to the ER, they'll get injured, they'll go to the ER, and then they'll not get a physician of record for a month or two or whatever. And so if this rule, this Bowie rule, didn't exist, then you would not be able to request comp from the date of injury up till, let's say, you end up finding a POR and 2 months later. You'd be limited to getting comp just from the first date you saw the certifying physician of record. So that's why this case is important. Pretty simple case, but it's helpful. And again, your certifying doctor will have to have reviewed all prior medical records and opine that yes, they do agree in their professional medical opinion that you would have been temporarily and totally disabled over that period of time. So I hope you found this helpful. I hope that maybe your attorney or whoever you're working with can use this information to get you compensation if you're entitled to it. Nevertheless, workers' comp is Ohio workers' comp is a particularly complicated beast. As I say in all these videos, don't do this stuff alone. Get a professional involved. Call up a workers' comp attorney. Look in Google. Search. Ask your friends. Ask your coworkers. Get a reference to somebody that you think you could work with. But you want to get somebody involved. It's going to pay dividends. It's going to be beneficial, and you're going to avoid making some kind of error or mistake that's going to hurt you. So if you want to email me or leave questions in the comments, please do. Or call my office if you have a work injury and you want to review the facts of your situation, and I'll look it over. Otherwise, I hope you're doing okay, and thanks for watching this video. Thank you. Bye.